Let's talk about this SNAP situation and why Justice Ketanji Brown Jackson might have granted the Trump administration a pause for this 24 hours. What if there are no more SNAP funds? What if the Trump administration has already drained all of that money? And that is the reason for this shutdown and the reason why MAGA Mike Johnson won't come back to work and why the Republicans refuse to negotiate with the Democrats. Maybe this is the reason. So this was over on Threads. This woman named Erica posted this. It says the USDA's own filing shows $750 million was pulled from the SNAP reserve before November even began, so before they ran out of money. By payment day, there were $0 left for new applicants or emergencies. They knew they spent it anyway. Embedded in her thread, she gives us the court case. So this is Rhode Island State. So in her threads, she gives us the court case. This is Rhode Island State Council of Churches versus Brooke Rollins, who is the Secretary of Agriculture. Now, I was just showing you that to know and understand where these screenshots are coming from. So this is coming from the actual court filing. So it says at the beginning of fiscal year 2026, FNS, and that stands for Food and Nutritional Service, had $6 billion in SNAP contingency funds. In October 2025, FNS used $450 million from the contingency fund for SNAP state agencies administrative expenses, or SEA. So that was administrative expenses, okay. And an additional $300 million for the Nutrition Assistance Program, NAP, block grants for Puerto Rico and America Samoa. So that right there is $750. So $450 million for admin costs, $300 million for Puerto Rico and America Samoa. That money came out of the reserves. And so then she pulls this quote from the court filing. It says, no funds will remain for new SNAP applicants, disaster aid, or as a cushion against collapse. That's the USDA's own line. It confirms the $6 billion reserve was already drained before the shutdown even began, straight from their October 31st filing. They knew it, they filed it, and they drained it before the shutdown even began. So this is one of the reasons why I don't think that they even want to start the government back up, because all of this will come out and money will have to be there. But where is the money? So that quote that she pulled is right in the court document, and that's what this screenshot is. Now, let's bring it back to this article. So it says, in SNAP appeal, Trump administration says it faces more harm than people who can't buy food. So they have to let these people go hungry. Otherwise, it's going to cause too much harm. All right, it says a judge told the administration to fully fund SNAP for the month of November. And I think that maybe Justice Ketanji Brown Jackson, maybe she's trying to see where all of this money is going. I don't know, but I'm sure she must have a plan. There is a paragraph on page 22 of the Trump administration's appeal of a federal judge's requirement that it make full November SNAP payments that has to be seen to be believed. The opening sentence asserts that the district court's order threatens significant and irreparable harm to the government, which outweighs any claimed injury to plaintiffs. In plain English, the Justice Department is telling the court that it would hurt the federal government more to comply with a judge's order requiring full food stamp payments than it would to hurt millions of low-income Americans to potentially starve. Let's simplify this further. The government is arguing that once the money is spent, it can't be unspent, and that would be horrible. But the hungry can't eat tomorrow, and that's not as bad. That is the contention. In a 40-page filing to the First Circuit Court of Appeals, the administration insisted that being forced to spend money Congress has already appropriated is a graver injury than the hunger and disruption that would follow from withholding it. Friday night, the administration filed a nearly identical emergency stay request with the Supreme Court, and Justice Ketanji Brown Jackson issued a temporary pause that will remain in effect until the Circuit Court issues a judgment on the matter. At stake is the Supplemental Nutrition Assistance Program, or SNAP, which provides monthly benefits to roughly 42 million Americans. During the ongoing government shutdown, the USDA planned to fund only part of the November payments, prompting lawsuits from cities, religious groups, and nonprofits that argued that the administration was flouting its legal obligation to deliver full benefits. Twice, a Rhode Island federal judge, John J. McConnell Jr., agreed, ordering the government to draw on existing accounts to cover the gap. Twice, the administration appealed, contending that the judiciary had usurped Congress's spending power by directing the executive branch to find the money. The Justice Department's latest emergency filing makes that claim in even starker terms. It asserts that McConnell's injunction makes a mockery of the separation of powers, and that there is no lawful basis for forcing the USDA to somehow find $4 billion in the metaphorical couch cushions. It also warns that by compelling compliance, the court has thrust the judiciary into the ongoing shutdown negotiations, implying that the judicial enforcement of basic statutory duties somehow exacerbates the fiscal standoff. And the interesting thing is they're able to find all kind of money for what was it, Argentina. They're able to find 20 to 40 billion dollars to send off to another country, but we can't find money to fund the SNAP benefits for America. Something definitely smells fishy in this situation. But what makes the filing remarkable is not just its tone, it's the value judgment embedded in it. Traditionally, when courts decide whether to grant emergency relief, there is a calculus. The courts consider which outcome would cause greater damage, keeping the challenged policy on hold or letting it take effect. Here, the policy in question is the administration's refusal to fully fund SNAP, despite having ample reserves, supposedly, but where is that money? All right, it says the Justice Department argues that the irreparable harm lies in being required to obey the court order and spend the money. By that logic, the government's institutional discomfort outweighs the hunger of millions of families, seniors, veterans, and children whose grocery money hangs in the balance. Whether in disputes over public health, environmental regulation, or economic relief, the Trump administration's lawyers have often equated executive prerogative with public interest, as though what benefits the administration necessarily benefits the nation. In this case, that conflation leads to the extraordinary claim that the government suffers greater harm by feeding people than by letting them go hungry. The administration's insistence that it cannot find the funds also rings hollow. By its own admission, the USDA controls multiple accounts with more than enough money to sustain SNAP for the month, including a $5 billion emergency reserve created by Congress specifically for that purpose. It has already drawn on similar pools of money to protect other nutrition programs from shutdown disruptions. The problem, in other words, is not fiscal incapacity, but political choice. The Justice Department's appeal thus functions as both legal brief and ideological statement. It asks the courts to privilege administrative convenience over human need. If that argument succeeds, the precedent would reach far beyond SNAP. It would signal that any time a court orders the government to meet a statutory duty to pay benefits, deliver services, or enforce protections, the executive may claim irreparable harm merely because it prefers not to act. That is not separation of powers. It is the substitution of political preference for law. Judge McConnell, for his part, put the matter bluntly. This should never happen in America. He was referring to the spectacle of a federal government choosing to let its citizens go hungry while pleading poverty amid abundant reserves. The Justice Department's legal arguments transformed that spectacle into doctrine. I know Donald Trump has complete immunity, but these people that are doing this sneaky stuff, they don't have complete immunity. And here Pam Bondi is celebrating having to pause SNAP from the Supreme Court. But will this stick and stay? And will all of these people get off scot-free? We will keep watching this. Y'all let me know what you